I'm Joe Harbaugh, the Dean of the Law School, and I'd like to welcome you to our law school community for this very important symposium that focuses on a slightly different community. Though it's only slightly different, because we think it's quite appropriate that this particular seminar is being hosted here at the T.C. Williams School of Law at the University of Richmond. Feel that way because we have, if not the first, one of the very first student organizations devoted to technology, the Law and Technology Association, among law schools in the country, and we are the first law school in the United States to require all of our students to come with Black's Law Dictionary under one arm and a laptop computer under the other arm. And we're proud of the fact that within 2 years, all 525 members of our community, every member of the student body, the faculty, and the staff will be linked together into our network. We have about a little over a third of us now, and in 2 years we'll have all of us. I hope, I expect that your day in Symposium will be profitable, that you will enjoy it, you will learn from it, and you will share ideas and get to know some of the people in our community. So again, on behalf of the law school community, welcome, and let me turn you over now to Rick Clow, who's the president of the Law and Technology Association and the organizer of the symposium. Rick?
Good morning. First of all, I'd like to thank Dean Harbaugh. I think sometimes students miss the opportunity to thank the appropriate people when that thanks is truly deserved. We have been extremely fortunate as students here at T.C. Williams to benefit from Dean Harbaugh's vision about how the law school should be networked and how that should play a role in not only how we view the legal profession, but how we learn about the law. We really have been very fortunate to have that. As he said, we are requiring now students to own computers upon entry at T.C. Williams. We will also be the site coming in April of the first online electronic law journal that will be published beginning of April. And we will be talking more about that later in the symposium. And I'm the editor-in-chief of that project. I'd be glad to answer any questions during a break or at lunch that you might have. Two of the speakers that you will be seeing today will be publishing articles in the first issue, and we will identify them as such. Before I go any further, we've got some scheduling changes due to the weather. So without going into too many specifics, we have had 2 cancellations, both snowed in the District of Columbia. And being from the north, I don't quite understand this whole concept of having the snow keep you from getting to somewhere. But Shari Steele of the Electronic Frontier Foundation and Meeks, author of CyberWire Dispatch, will not be attending the symposium today. In Shari's place, we have arranged for Peter Harder, who's the Executive Director and General Counsel for the National Public Telecomputing Network, which is the parent organization to all freenets in the United States. He will be speaking about community and cyberspace later on this morning. We will be having lunch around 12:30. That break will go until about 1:45. We will have 3 presentations in the morning session rather than 4. They will each be slightly longer than the initial presentations have been. I think we'll give the speakers about 50 minutes instead of 40. Having put this symposium together, all we envisioned this being was a chance for the audience to learn about the issues that we're talking about. And in doing so, we have asked each speaker to prepare part of a lecture, but I think perhaps the most valuable part of that is going to be the chance for the audience to react to those presentations. So questions are encouraged. Each speaker is aware that they will be fielding questions after the conclusion of their formal lecture. And I would encourage anyone, be you a law student, a professor, a lawyer, or just a member of the public who's interested in the issue, to please ask your questions, get them addressed, and find out what our various presenters have to say. All right, that's out of the way. If you have any questions about specific scheduling problems, those of us in the LTA have name tags. You can come up and ask any of us exactly what's going on, and if we happen to know, we'd be more than happy to answer those questions for you. In addition to those of you that are in the courtroom, I think it's important to know that we are joined virtually, if you will, by members around the world on the internet. We've had requests for the publication of the results of the symposium from no less than 6 countries on the internet, including Australia, the UK, Ireland, France, Belgium, South Africa, and several others. They've seen the information that the LTA has placed on the internet about the symposium, and obviously a trip to Richmond, snow or not, was not going to be in the cards for them. So they are kind of waiting with bated breath, and as quickly as we can turn around and produce the results in some kind of printed form, we will be publishing, quote unquote, the results on the internet. And people will have a chance to look through some of both the presentations that are made as well as the questions and answers, which I think will probably be more revealing for those members of the internet that will be joining us. About 2 years ago, some of you may be familiar with the situation of Cantor and Siegel. They've become quite a pair in the net community, and I bring them up for one reason only, certainly not to glorify them. They are a husband and wife team of attorneys who discovered a way to post thousands of messages to every bulletin board on the internet at the same time. It was the same message. It was about getting a green card in the United States. And they quickly became what's known as a net legend. This was, and not a good one at that. The amount of resources that they used in doing so was obscene. The number of users around the internet that they cost money, basically, who pay for their access, was astronomical. And it was truly one of the best examples and one of the most polarizing examples of how the, if you could call it a community, of internet users reacted en masse to a situation that they really didn't like. Undaunted by the intense negative reaction of the net community, Cantor and Siegel rather cavalierly, in my opinion, have gone forward and published a book called How to Make a Fortune on the Information Superhighway. Those of us who have had a chance to read the book have been rather amused by some of their assertions. I'm going to read a quote to you that I think provides the perfect starting point for the symposium and is perhaps something that we can revisit throughout the day that will help us really address the question of whether or not there is in fact a community. And I'm reading now from the text. Some starry-eyed individuals who access the net think of cyberspace as a community. Don't you believe it? There is no community. Along your journey on the net, someone may try to tell you that in order to be good net citizens, you must follow the rules of the cyberspace community. Don't listen. The only laws and rules with which you should concern yourself are those passed by the country, state, and city in which you live. The only ethics you should adopt as you pursue wealth on the highway are those dictated by the religious faith you have chosen to follow in your own good conscience. Now, that strikes me as a rather bold assertion, given their past activities. But I think it would be a good framework to listen to some of the presentations we're about to hear. Because indeed there is a debate as to whether or not there's a community. If there is, there are some legal implications to how we view that community, and I think really that's what we're here today to discuss. Our first speaker is Dan Burk. He is an assistant professor of law at George Mason School of Law. Dan teaches evidence, trial procedure, intellectual property, and a few other courses. He is the author of numerous papers on the legal and societal impact of new technologies and the intellectual property implications of global computer networks. Dan will be one of those authors publishing his presentation in the first issue of the Richmond Journal of Law and Technology. And I would like everyone please to welcome Dan Burk, talking on trademarks in the national information infrastructure. Dan?
Thanks very much, Rick. That quote that you offered us from Cantor and Siegel, known on the internet as the green card lawyers, is an interesting place to start out. Because one of the reasons I've found the development of the internet over the past several years to be an interesting research topic is the change in community and the shift in values, the shift in rules of the road that's taking place online. And it parallels in very interesting ways some of my other research in the area of biotechnology. Now that wouldn't immediately spring to mind. You think about, well, biotechnology is kind of a wet science. The internet has more to do with electronics. It's sort of not directly connected, you would think, to chemistry and biology and those sorts of things. But we have to remember the history of the internet. Internet really was originally developed as a Cold War technology, a system of computers talking to one another via the internet protocols, some machine languages that allowed machines to talk to one another, and was developed initially as a communication system that would withstand a nuclear attack or some type of sabotage, because there is no centralized authority. There is no central coordination. Each machine acts independently, but coordinates with one another, and there's a sort of electronic invisible hand that allows the machines to all work together in a efficient fashion. And arising as it did out of DoD research, internet quickly became the provenance and the prerogative of the scientific research community, particularly funded researchers, people who received research grants from the Department of Defense, NSF, NIH, or other federal agencies. And so the internet was really the creation and the tool of the scientific community, and the values on the internet reflected those values of the scientific community. There is sociological research going back several decades now showing that there is clearly a community of scientists, and that there are informal, unwritten rules among scientists that you have to participate in order to be considered a good scientist. You're supposed to share your information with other people freely. You're supposed to dedicate your research to the community. You are supposed to not seek monetary gain. The reward for being a good scientist is the acclaim of your peers. People seek the Nobel Prize not because of the cash award. Scientists want the Nobel Prize because that's the judgment of their peers that they are a successful and worthwhile researcher. Scientists are supposed to be disinterested. They're not supposed to be openly seeking personal gain. They're supposed to be objective about what they do. Well, these values of the scientific community were adopted as part of the original internet community, which was in fact the scientific community, and we can still see these values reflected in the present netiquette or rules of the road that we find on the internet. There is still a feeling that one should not openly seek commercial gain. There is still some feeling that one, when one is using the internet, should devote one's resources to the community. And so, for example, when lawyers or attorneys who do want to use the internet in a proper way, not like Cantor and Siegel did, but want to use it in a proper way that's acceptable to the internet community, go online, they will offer free information. Set up a website or an archive site and offer free legal information to the internet community. People will use that information. They will accept that information into the great database of the network. And if they need additional counsel or additional information, they will remember that this person, this law firm, contributed to the community and presumably will go back to pay for other information. And that's the way that you're supposed to do things. That's the acceptable way to do things on the internet. What we're seeing is a shift, though, from that scientific, community-based set of values to a somewhat different set of values, because the scientific community, although they may not be racially or gender or nationally homogenous, all share a common goal to advance the cause of knowledge. People are now using the internet for many nations, many different walks of life. They're certainly not all scientists. People have different expectations as to what the internet should be used for and what they should be able to do online. Cantor and Siegel, you've just heard about their expectations to what they should be allowed to do online. And so there's no longer this informal compact among members of the net community or internet users. It's no longer understood what one should do. And we're beginning to see some conflicts, some disputes. And as with any human activity where there are conflicts or disputes, you need some dispute resolution mechanism. If you have a small community like the scientific community, you may be able to have an informal dispute resolution mechanism, like ostracism. If you're a bad scientist, or you forge your data, your colleagues will no longer respect you. They may throw you out of the university or the laboratory, and perhaps the courts don't need to get involved. But when you have a large, diverse community, you begin to need some more formal rules of the road. You begin to need some more formal dispute resolution mechanisms. And the ones that we've developed generally in society are those that we're familiar with as legal institutions, whether it's legislative institutions, courts, administrative institutions, or whatever. And what we're really here to talk about today, at least in the first few presentations, certainly in mine, is the extent to which those dispute resolution mechanisms from real space, administrative agencies, administrative law, courts, judge-made law, legislatures, statutes, to what extent are those applicable online? To what extent can they help either reinforce or bolster the informal rules of the road in the internet? To what extent are they not applicable? Do they not have a very good fit? Old guard members of the internet community view the legal establishment with some suspicion. They will frequently tell you that copyright will not work on the internet. They'll tell you that other sorts of laws and legal institutions will simply not work on the internet. And the question we need to ask ourselves is that really true? Or can the law be helpful here? Can the law handle this new medium? I'm going to suggest that for the most part the law probably can, and I'm going to offer you one concrete example of how that may work. With regard to the law of trademarks. One of the disputes that's arisen as the internet has become a commercial medium, as we've moved from government sponsorship and strictly research use to different kinds of uses, is a dispute over trademark use. Now, if you had asked most of us about this even 6 months or a year ago, we might have told you that the major intellectual property problems on the internet were going to all be copyright problems, maybe a few patent problems. But we were surprised, and there are a number of trademark disputes we've already seen here online. Some of these you've seen in the newspaper, they'll be familiar to. The famous MTV versus Adam Curry dispute. Adam Curry was a VJ or a video jockey with the MTV broadcast programs. Curry developed with the advice and encouragement of MTV, he developed a network site, MTV.com, where people could come to talk about MTV, talk about celebrities, talk about rock music. Curry and MTV have since parted ways. He's left their employ. And as he was cleaning out his desk, they also asked him to please give up his net site because it says MTV, MTV.com. Curry felt that he had worked hard to build up this place on the network, on the internet. He felt that he'd worked hard to develop that, and he declined to surrender it to MTV. And so they now have an ongoing dispute about the ownership and control of this internet site. There's also the very famous Kaplan versus Princeton Review dispute, which you may have seen reported in the newspapers. Stanley Kaplan review courses and the Princeton Review, of course, both offer courses for students who want to take standardized tests, the SAT, the LSAT, MCAT, and so on. And they're rivals in the market for those services to prepare students for those tests. Princeton Review, being a little bit more technologically minded, decided that they would create an internet site where people could talk about their services, where they could advertise their services, where students from their courses could discuss these standardized tests with one another. And so they went to the authority that registers names for the internet and parcels out positions on the internet. And they registered a number of different site names, Princeton.com, Review.com. And while they were at it, they registered Kaplan.com. Kaplan, of course, being the name of their major competitor. They have openly admitted that they did this to annoy their competitors. They set up a service, a computer service under that name that they openly admitted they were hoping students and potential students would sign on to that service, thinking that it was from their competitor. And when the students did sign on, they received information about how good Princeton Review was and how bad Kaplan's review courses were. Kaplan found out about this in fairly short order, threatened legal action. Princeton said, well, we did it as kind of a joke. We'll give you back the name of the internet site in exchange for a case of beer, either domestic or imported. Kaplan declined to exchange the name for beer. They went ahead into arbitration, and the arbitrators eventually told Princeton that they needed to turn the name back over to Kaplan, and that has been done. Princeton said that Kaplan really could have saved themselves the money of litigation and the arbitration. According to the head of the Princeton Review, they said Kaplan has no vision, no sense of humor, and no beer. I mean, so this is really sort of a very acrimonious dispute between two rivals. Princeton has now, having surrendered the name back to Kaplan, announced their plans to register a different internet name, Kraplan, K-R-A-P-L-A-N, where they intend to do the same thing that they had done previously, give information out, comparative information about how good their course is, and tell horror stories about their competitor. There's also the very famous McDonald's.com dispute. The last time I checked, it was ongoing a few days ago. A reporter decided to demonstrate how easy it is to register and adopt the name of a well-known business on the internet. Checked around and discovered that McDonald's had done nothing online and that no one had registered the McDonald's name as an internet site. And in fact called McDonald's, trying to generate an interesting story on this, and informed them, you haven't registered your name with the internet, you have not protected your name. Your competitors could register it, just like happened with Kaplan. Burger King could register McDonald's.com, and got very little response from McDonald's, so he went ahead and registered it himself. And his email address there is ronald@mcdonalds.com. He announced this in columns that he wrote for a number of magazines, including Wired. Wired is a magazine that's frequently read by computer users and internet users. And he says he's received a great deal of mail at this internet site. He said about half the mail encourages him to sell the name back to McDonald's for a large amount of money. The other half has encouraged him to use the site to promote vegetarianism. And McDonald's eventually noticed this activity and has performed a number of maneuvers to try and get their name back, has asked the registry to invalidate this. That was eventually unsuccessful, has threatened litigation, and this dispute is ongoing also. Finally, we see the incidence of what I call squatters, people who don't necessarily own a business. They're not reporters, they're not Adam Curry, they're not the Princeton Review, but they are somewhat foresighted, and they have gone out and have registered the names of various well-known publications, businesses, and so on, such as Esquire.com, in the hopes that someday Esquire magazine might be interested in doing something on the internet and their name would be taken. Coke.com, C-O-K-E, in the hopes that the Coca-Cola Company would one day want that name back. And apparently these individuals have the, well, they're doing what my economist colleagues call rent seeking. They're hoping that when these businesses come online, they'll want their names back and they will pay them some amount of money in order to get the names. So as you can see, there's a fair amount of trademark dispute already, primarily over domain names on the internet, and we'll talk about what domain names are in just a moment, but the names of well-known services, well-known businesses from real space that are being transported in cyberspace. Now, how do these kinds of disputes arise, or why do they arise? Well, we need to talk for just a minute about what these names are used for, where they come from. I said a moment ago that the internet, there's really a lot of computers that are able to talk to one another using internet protocols. It's been described as a network of networks. In order to use the internet, a computer has to know its own identity. It has to know that it's not some other computer. Electronic mail that's sent between computers has to be addressed. It has to know where the mail is going, and the computers pass it from machine to machine until it reaches its destination. Has to know where the mail came from. Everything on the internet has to have some identifying mark. And that may be a computer on the internet that needs an identifying mark. It may be a radio telescope. It may be an electron microscope. There are an odd assembly of things hooked up to the internet. There's the very famous Coke machine at MIT. The computer science folks at MIT got tired of going down to the basement to get a Coke and finding that the machine was out of Coke, and so they hooked the machine up to the internet, and from their terminals upstairs they could query the machine, is there any Coke left? If there was, then they would go downstairs and buy some. If there wasn't, then they wouldn't bother. The famous internet toaster, which I'm informed has unfortunately been taken offline, but for some time someone had their toaster hooked up to the internet, and it was possible to pop the toast. You could change the voltage in the toaster and pop the toast. That's unfortunately offline now. Someone else has put their hot tub on the internet. You could query the hot tub and find out what the temperature of the water is, whether the lid is open or closed, and so on. So it may be a computer, it may be a hot tub, it may be your toaster, or whatever it is hooked up to the internet, but it needs to know, it needs to have an identity, and you need to be able to find it. Well, the internet does this at present via the IP addresses, Internet Protocol addresses. There's a new version of the Internet Protocols coming out that will change this slightly, but the idea will be pretty much the same. The Internet Protocol addresses are a series of numbers or fields separated by dots, as you can see, that designate the network that item, toaster, computer, whatever it may be, designate what that item is and which network it's on. It gives it an individual identity. These addresses, these series of numbers, are assigned by the Internet Assigned Numbers Authority, IANA. IANA has delegated day-to-day assignment of these addresses to the Internet Registration Service, which is run by Network Solutions here in Virginia, in Herndon, not too far from where I live, actually. So if you want to hook up to the Internet, your systems administrator, systems operator, computer, you would go to the Internet and ask them to assign you an address, and they would handle that for you. These addresses are not very user-friendly, however. You can't tell from looking at this example that I've given you where that computer is located, who it belongs to. If you wanted to find that computer again, or that toaster, you might not be able to remember this number very easily, sort of like remembering your PIN number at the ATM. If you didn't get to choose the number, you may not be able to remember what number you were assigned. And so the folks who designed standards for the Internet developed a system that would allow the addressing of Internet objects to be somewhat more user-friendly. The so-called domain name system. And you're familiar with these if you've ever spent any time online. These are some fairly common email addresses, domain names, and these are essentially overlays on the number addresses that I just showed you. For example, Dickens@alder.twist.com. That is an overlay on some internet address. You see that the overlay, the domain name, still has fields separated by dots that generally designate the particular user or item in the right-handmost position, and then the computer, the network, the subnetwork that user is at. The last three letters are the well-known top domain names. COM indicates that is a commercial site. Somebody is selling something or doing commercial kind of business there. EDU is an educational site, usually a university of some sort. So you might have Shipley at Silo, University of Southern North Dakota. EDU, which indicates that you have an educational institution there. Org, Python at flying.circus.org is some type of organization that doesn't fit well into the other categories. MIL is the military network designation. So you might have Strangelove at holocaust.mil. It tells you that's a military address. Babbage at difference.engine.net tells you that that is someone who is running a network or subnetwork on the internet. GOV, of course, is the government network indicator. And finally, there are a number of geographic indicators. Fergie at windsor.castle.uk would tell you that that was in the United Kingdom. CA would tell you it's in Canada. NL would be the Netherlands, and so on. These are much easier to remember than the plain numbers. They give you a mnemonic handle on where things are. Now, they may give you some geographic information, like the UK designation, but not necessarily. Yeah, it's entirely possible for the site that's using this to move and take that name with it. Because remember that these are overlays. Right? These names are overlaid on the numbers on the internet addresses, and they're separable. You could pick up and take your name with you to some other site, to some other computer or network that has a different underlying number address, but you could continue to use your name conceivably. Now that leads us to sort of a problem. Are these domain names, are they names or addresses? And if you think for a moment, you begin to realize that it's hard to tell. Think about your personal name. You carry that around with you. It doesn't stay in a particular spot. When you get up and leave your chair for lunch, you'll take that name, that designator with you. So we think of that as being a name since it's kind of portable. Your telephone number. Is your telephone number a name or an address? Well, within an area code, it's very frequently possible to take your telephone number with you. So that means that it's something like a name. On the other hand, if you have a modem on your computer and 2 telephone lines, if you put your modem on one telephone line, it will be at one number. If you put it on the other line, it'll be at the other number. The computer, the modem, doesn't take that with it. So in some instances, your telephone number may function as a sort of an address. It stays in the same place. It's not necessarily portable. Street addresses, we tend to think of those as being not portable. You don't usually, when you move to a new house, take your street address with you. On the other hand, is there any particular reason why you couldn't? The street address is really an overlay, in some sense, on other kinds of designations, like latitude and longitude, right? Latitude and longitude is supposed to have be a permanent designation. Conceivably, you could move street addresses or have the same street address at different latitudes and longitudes. So your street address is really, in some sense, an overlay. Zip codes don't move around much, so they seem like they're part of an address. On the other hand, you can refer to a particular zip code to designate an area, use it as a name. And finally, the familiar file directories on your computer. Every file that you have on your computer, assuming you want to find it again, has a name, but it also has a pathway that's part of that name that enables your computer to find it. So file directory designations act in some senses as names and in some senses as addresses. Right? They identify the file on your computer, but they also allow your computer to find it again. Now, how about these internet domain names? Well, as I said, they are somewhat portable, so they tend to function as names rather than addresses. On the other hand, they do allow users on the internet and machines on the internet to find one another, so sometimes they operate as addresses rather than as names. And that makes them a little bit odd, but not as odd as you might think. A lot of folks have said, well, trademark law on the internet is going to be difficult to apply because domain names are sometimes names and sometimes they're logical addresses. But as you can see, in real space, we have the same thing. Right? With the exception of your personal name, almost everything on this list can function as either a name, an identifier, or as a logical address. So things in cyberspace aren't quite as different as you might think at first glance. Now, if we are going to think about applying trademark law to these disputes over domain names, be they names or be they addresses, we're going to need to think a little bit about the basis of trademark law. So let's run through a quick review here. Trademarks generally come in several flavors. Trademarks are used to designate services or products in commerce. The underlying rationale for trademark law is really twofold. One of the primary policy reasons for trademark law is to prevent consumers from being confused. We don't want consumers to buy the wrong product or go to a service when they think that it's really someone else's service. They allow consumers to distinguish among the quality of products and services. And along the way, while trademarks do that, they also allow businesses and services to protect the goodwill, the reputation that they have developed among consumers. We generally find courts and commentators talking about 4 categories of trademark that may be familiar to you: arbitrary terms, suggestive terms, descriptive terms, and finally generic terms. And going from the top to the bottom, each of these gets more protection and more deference by the legal system. Arbitrary terms get the most deference and the most protection, and then suggestive terms get a little less, all the way down to generic, which you may be aware of, get very little and usually no protection as trademarks at all. Well, how do we know an arbitrary term from a suggestive term? Courts talk about it in this way. Arbitrary terms tend to be those kinds of terms that have no logical or suggestive relation to the actual characteristics of the goods. So if you think about Exxon, if you were from a country unfamiliar with the Exxon Corporation, and I simply said Exxon to you, it's unlikely that you would quickly realize that that was a service for gasoline or for automotive services. Suggestive trademarks suggest to the mind the characteristics of the goods. Descriptive terms flat out describe the characteristics of the goods or the things that are sought in the article. And finally, generic terms are common descriptive name of the class of goods. If I simply call my potato chips, that's generic. Everybody calls that potato chip. If I call them potato chips, maybe I get to have something that's a little more descriptive, and I can become more and more fanciful and get more and more protection as a trademark. Generic trademarks get little or no protection. Descriptive trademarks may get some protection if they have developed what's called secondary meaning, which means that the public has become accustomed to identifying that descriptive mark with that particular brand of those goods, rather than using it to describe the whole class of goods. And this is fairly common hierarchy that we'll find in cases and in the treatises on trademark. Now, I said one of the most important questions in trademark law policy around is to try to prevent consumers from being confused. Courts look at these kinds of factors to decide whether someone's going to become confused. First of all, what's the strength of the mark? Is it an arbitrary mark that gets a lot of deference and is a very strong mark? Or is it a generic mark that everyone uses to describe that class of goods, and so it deserves very little protection? We don't want to give one person the rights to a generic term because everyone needs it to describe their goods. On the other hand, a fanciful or arbitrary mark is a very strong mark because you don't need it to describe your goods. If it already belongs to someone else, you can come up with your own fanciful mark. The degree of similarity between marks, if they're very similar logos or very similar kinds of words, we might expect people to become confused as to what the source of that good or that service is. The intent of the defendant in adopting the mark, which courts sometimes talk about in terms of bad faith by the defendant or bad faith by the junior user. If you specifically adopted this mark in order to try and confuse people, or in order to try and siphon off some of the goodwill that's accumulated to your competitor, courts think that that means there's a higher likelihood of confusion. If you can show evidence of actual confusion, people bought your competitor's goods thinking that they were your goods because of the fact that they were labeled or marked in a certain way, that's good evidence of likelihood of confusion. The proximity of the products, this is a virtual kind of proximity. Are they products in the same market? If I sell Apple computers versus selling actual apples, those are probably in different markets. People are unlikely to confuse those because someone who goes out looking for something to eat is not likely to buy a computer. Are they marketed in the same channels of commerce? Well, if I'm going to buy an apple, I'll go to the grocery store, probably, or to the fruit stand. If I want to buy a computer, I'll go to some other kind of store. So the markets and the channels of marketing, the channels of distribution, if those are very close together, people may likely be confused. If they're farther apart, they may not be. Quality of the products. If the products are approximately the same price, same quality, consumers may be likely to be confused if they have very similar marks. And finally, the sophistication of the buyers. If I'm someone who is going out to buy a computer and I'm a well-educated person who's done a lot of background research, I may realize, well, okay, I know that this brand of computer X looks very much like Y, but they have different hard drives and they have different processors, and I'm a sophisticated buyer, so I'm not going to mistake those. If I'm not such a sophisticated buyer, I may be likely to confuse them if they look similar on the outside. So those are the kinds of things, of course, we're going to look at. Now, if you run down this list and you take one of our internet trademark disputes in mind, you can quickly see that there is some likelihood of confusion with some of these, right? When you think about, for example, our Kaplan versus Princeton example. Strength of the owner's mark. Is Kaplan a descriptive mark, generic mark, suggestive? When you say Kaplan, I don't get an impression when I say that this is necessarily someone who offers review courses, right? Except that I happen to know from long experience in advertising that Kaplan offers review courses, so that seems like a pretty strong mark. If the competitor adopts that mark for an internet site with that exact same spelling, those marks seem pretty similar. What was the intent of the defendant in adopting the mark? Well, Princeton Review has openly admitted that they wanted to have Kaplan's potential buyers sign on to this site and be confused, get information about Kaplan comparative with Princeton Review. Evidence of actual confusion, yes, people actually did sign on and believing that this was Kaplan's internet site. Proximity of products, well, that's a hard one to designate the market, right? You might say, well, one's on the internet, one's in cyberspace, the other one is out in the real world in the classroom where you actually offer the service. Same with Coca-Cola.com, right? One is a soft drink out in the real world, the other one is a site on the internet. So maybe that's a place where you can distinguish the two. Quality of the products. Since you distinguish those, it's sort of hard to apply that factor. Sophistication of the buyers. That's kind of a tough one too. People online are fairly sophisticated. They may or may not be sophisticated with regard to soft drinks or regard to review courses. So you can certainly see that there's room to apply these tests on the internet. Let me finally mention and then take a few questions that there is some case law there that we might be able to apply to this situation. There are a series of cases dealing with telephone mnemonics. One of my favorites, the Holiday Inn case, or start with Bell versus Kiden. Bell versus Kiden, some lawyers, one lawyer had offered his advertising the mnemonic, when you push the buttons on the telephone, call law, CALL-LAW. Someone else wanted to get the designation 1-800-LAW-CALL. There was a lawsuit about this. Was it confusing? Court found that the mark was suggestive or descriptive, had no problem saying, yes, it is in fact a legitimate trademark, even though it is an overlay on the telephone pad, keypad. But the court said we don't think that the customers will be confused because one was an 800 number and the other is a local number. And there are quite a few of these cases. Interestingly enough, most of them seem to involve lawyers. Here's another one. Ralph Pearlstein Associates versus Sklar. Personal injury lawyers, one had a designation in his advertising, call INJURY1. Someone else came along and said, call INJURY9. Court said, well, injury is generic. All personal injury lawyers probably need that word to advertise their services. And they remanded for findings on the likelihood of confusion between the non-generic portions of the mark, which are 1 and 9. Will consumers be confused between these two marks and call the wrong lawyer, or can they distinguish based on that last numeral? And there are quite a number of these cases. So there are some precedents in real space that seem like they apply in cyberspace. And with that, I'll close and take some questions about names, addresses, and trademark law as it applies to cyberspace. Yeah. Domain names are assigned by the internet on a first-come, first-served basis. And that's why squatters can do what they do. They can just get there before the business does and register it. And internet has said, we're not going to get involved in doing trademark examination. We'll give it to whoever shows up first. So the squatters have these names fair and square according to the process. The question then becomes not so much one of trademark law, but really one of cost-benefit analysis. If you're Coca-Cola, you can try and get your name back. As I said, Coke.com has been registered by somebody else. You can try and get your name back by litigating, and as those factors you suggest, is this person using it? Are people likely to become confused? Will come into play. Or if you can give the guy $50 and he'll go away, you're going to do that, right? So the real question is what cost-benefit analysis is the company going to do? McDonald's has been very upset about Ronald@mcdonald.com. Coca-Cola really hasn't done much. They've just gone ahead and registered some other domain names. Coke.com is gone, so they registered Coca-Cola.com, and they're using that instead. And they may not pay the guy anything. It's very much going to depend on a case-by-case basis. But only when you get to litigation are those factors going to come into play, and it depends on how aggressive I think the business is willing to be. Yeah. That's quite right. Absolutely. That's probably the most difficult question that we're going to face. There's a fair amount of, looking from the American perspective, there's a fair amount of case law suggesting that our courts are willing to enforce trademark registrations beyond the bounds of our national boundaries. Now, the problem then becomes, can you enforce that judgment in a foreign country? Frequently, in a third world country, the answer is going to be no, and it's going to be up to the State Department to put pressure on that other nation to acquiesce. Right now, internet registry is centralized in the United States, and the internet has designated some foreign subsidiaries to take registrations in those countries, but really everything happens through the United States. Of course, yeah. That's right. That's right. Absolutely, and even more interesting than that to me is the question of the so-called race to the bottom. If I want to attract some business to my country, there may be incentives for me to have very permissive trademark laws or very permissive copyright laws or whatever. My guess is that some countries will want to become internet trademark havens, you might say, and actually induce people to set up these sorts of things there to attract capital into their borders. Very much so, very much so. So all the kinds of gray market questions that we're familiar with from real space, trademark conflicts questions we're familiar with from real space, are going to be translated in the internet. I think as you see, we have some precedent and we can apply real space law, but it becomes complicated in the situation you posit, which is the international situation where we're trans-border, transnational. And there we're going to be really in the realm of diplomacy and very interesting conflicts questions. Yeah. To what extent can the registry, the internic, was that the question? Yeah. Part of the reason that the internic, the registry, has taken the position that it has is, I think, to avoid exactly that problem. They simply say, hey, we just take people on a first-come, first-served basis and we don't get involved in this. There are a couple of these telephone cases that offer very interesting parallels. You saw the 800 number question. 800 numbers are assigned in blocks to different access providers. And they're assigned, in the case that you saw, people then came and asked for particular numbers, including numbers on a first-come, first-served basis. And they did attempt, in fact, to join the access provider, the telephone company, in the lawsuit. They were able to duck behind common carrier status. So they fulfilled their duty by simply assigning a rational allocation system, which was first come, first served, and so they weren't able to be joined. Yeah. I think you're right, there's a difference, but I'm not sure it's a material one. I'm not sure which way it cuts, because with the phone number, there's a direct correspondence between the numbers and the letters. Right? I mean, there's a convention that you've got 3 letters per number, and there's some redundancy in the code, as we would say in biology. You get any of those 3 letters to that number, but there's only one number. So once you've got that number, you've got that name or that mnemonic locked up for that area code, right? The same is not necessarily true for the internet. There is no one-to-one correspondence between the address, the IP addresses that you saw, the numerical fields, and the name fields. So you can overlay any word that you want on top of that, and you can freely buy and sell and exchange or trade these words that you overlay. And so you're not stuck with one designation as you would in the telephone. So I think you're right, but it's possible that may even cut the other direction, right? Because you're not locked into that one call dash law, or if someone has injury locked up in an area code, someone else can use that. With the internet, you can use that word for a different IP address on maybe a different subdomain, or you can use some completely different word that would not have numbers. Yeah. No, there is no requirement. In fact, my understanding from talking to the folks at Internet is you don't even have to show that you have a domain or a computer online yet. You can simply show up and say, well, I intend to put a computer online, or I want to put a computer online someday, and I want to register these names. And if you're the first person there to ask for that name, it's yours. Yeah. For each of the, excuse me? Not really. As I said, for example, with the geographic designations, Geographic designations, if you saw, you know, .uk or .ca, originally that meant that it was in fact located in the United Kingdom or in Canada. Since then, it really doesn't mean anything because people have picked up and moved to different sites and they wanted to keep that mnemonic and they've taken the UK with them. So now they may be in Ireland or they may be in Australia or the United States even. So although supposedly originally these top level domain names meant something, certainly with regard to the geographic indicators, they don't mean anything anymore. And some of the others are becoming very fluid also. Yeah. Well, if you call yourself CodeCom, you're certainly implying that you have a commercial business. You know, maybe you supply contraband substances. Maybe you supply soft drinks. Maybe your initials happen to be COKE. You know, with MTV, that's going to be a question. Iron Thomas Vladimir. Should I be able to get MTV, or does that really mean something on the internet? Apple, you know, Apple.com. Apple has their own network. And you might associate with Apple computers, but if the Apple Grower Association wants to come in and, for example, have apple.org, is that likely to be confusing to people? And if it is, does it really matter? If you sign into apple.org and say, hey, what's the latest on the Macintosh? And they say, well, they're growing very nice. You know, is Apple really going to lose any business? Yeah. That's right, no, but I mean, is there a likelihood of confusion there? Well, maybe, and if there is, does it matter? If you sign on and ask about soft drinks and they say, I'm sorry, all we do is Bessemer converters, maybe that doesn't affect materially the soft drink business. Yeah.
And one last thing that might get things further, I think this whole debate is just beginning. The point about the geographic domain names, that brings that far also procedure questions. It's not only a trademark.
Absolutely. There's going to be a very difficult series of questions, not with regard to trademark law, but also you're going to hear about copyright in a moment and other things, with regard to physical location of the organization and hardware, virtual location of the network, and jurisdiction, and then once you get, if you can get the jurisdiction problem solved. That is an area where the law is probably going to need some amendment because we haven't really dealt with that before. That's not a close parallel like we can see in real space to cyberspace for trademarks. The jurisdiction questions are going to be very difficult. Yeah. That's exactly right. Recourse is to register as many names as possible, and that may create perverse incentives. There's a fellow, some of you may know by the name of Ed Kitch down here at UVA, who wrote about patent law with this regard. And his idea was that patent law is really very much like a property right that prevents overexploitation of a resource too soon. Patent law was set up to avoid that. What we apparently have right now with regard to internet. They register names they're never going to use. They may spend time and effort registering names that they shouldn't be bothering to do. But to protect their position in the future, that's the only recourse they have right now. Follow, yeah. Mullins tried to do that after the fact, and initially had some success. Internet was talking about pulling that reporter's registry at McDonald's.com. They eventually decided, after reviewing the problem, that they simply do not have the resources to do trademark marketing. They don't have the resources to trademark survey or even probably file all the possible leaks. Afterwards, someone came in and said, "Hey, that's my mark. How do you know who has the prior claim, who has the better claim?" In the real world, we developed the trademark office to do front-end searches, and we developed the courts to do back-end searches, right? If you say, "Hey, that's my mark, I have a prior claim," then you go ahead and litigate to clean that up. So the possibility would be that the Internet Registry would either turn into the trademark office to do front-end searches or into
And we'll let the stragglers come in as they do. Before I introduce our next speaker, I do want to point out there are a few people here that, having been one of the people organizing this event, it is truly a pleasure to have them in the room. First of all, I own a discussion list on the internet for law students, and one of the nice benefits of running that, one of the truly unexpected benefits, is that we have almost as many practitioners and lay people who are interested in law and technology as we do law students. And one of the people in the audience today is Jim Coleman, who's an attorney from Minneapolis, who actually, proving again that Northerners actually can navigate through snow. He drove all the way out from Minneapolis, and I want to extend a thank you to Jim for making it out here. There were also a trio of students from Ohio who called me about a week and a half ago and asked if we would be able to accommodate them. And I said, you know, of course, I wanted to make sure we had people in the audience, and the more the merrier, to be quite honest. And they also drove out yesterday, getting to my apartment last night about 2:30 in the morning. So I'd like to welcome Ed, Tara, and I'm forgetting your name now. Dane, there we go, who have driven out from Ohio, and they've got a long drive ahead of them tomorrow. So again, thank you to them. There are some others, a couple of students, law students from Syracuse University, one who was fortunate enough to fly, the others who drove. So we truly, as having been a law student organization, to have organized this event and to have seen both the practitioners that have come out today, but also the law students from around the country that were interested enough in the topic to devote a weekend of driving effectively to come out here is quite gratifying, and I want to thank everyone for doing that. Our next speaker is a professor of law at William & Mary, right down the road in Charlottesville. Charlottesville, Jesus, I'm blanking. Williamsburg. Totally inadvertent, Trotter. My apologies, right off the bat. That was, wow, same road, 64, I apologize. Wow, I am not going to hear the end of that, I think, until, it'll take a lot to live that down. Trotter teaches intellectual property, torts, and law and economics at William & Mary, and has authored several papers on the design of computer command languages, Law and Computers and Jurisdictional Issues of Cyberspace. He's going to be addressing us today talking about copyright and the National Information Infrastructure. Trotter is also an owner of a discussion list on the internet, kind of the big guy version of the list that I run. His is more for the practitioners, the law professors, called Siberia, and it has been a pleasure to have basically been a lurker on that list and to watch as the people who are really leading the field discuss all of these cutting-edge issues. It's where, in fact, I first became aware of both Trotter and Professor Dan Burk. Trotter is also hosting an upcoming symposium at William & Mary. I got it right that time. Next month on privacy and access to information that I'm sure he'd be happy to tell you more about, either in his talk or if you can catch him at lunch. He will also be presenting his presentation today in the first issue of our journal. So I would like everyone to please welcome Professor Trotter Hardy.
Thanks, Rick. It'll take me 5 or 10 minutes to come up with a really snappy comeback about Charlottesville, but I will. I do want to talk about copyright on the net and cyberspace. And copyright's obviously real important, and people talk about it a lot, and there's a kind of prevailing notion that copyright dates back to the print era, the 18th century, and it was based on a print model, and all that's got to change, and copyright's dead, and all that sort of stuff. And I think, like myself, I think like Mark Twain, that rumors of copyright's death are greatly exaggerated. Because I've been also doing a little bit of copyright history, and I know that copyrights had to cope with a whole bunch of technological changes over the centuries. First, photography, the phonograph, movies, player piano rolls, computer programs, video recording, all sorts of things. And it's managed to adapt and survive. But adaptation is what it does. And I think even though I think copyright will survive, I think it's going to be under a lot of pressure for change in a number of areas. And I want to talk to you about one particular area today that I think is going to be under particular pressure, and an area that you might not think of, and that's the area of copyright preemption of state law. And I think it's going to be a major, major problem area in the next decade, and I want to try to show you why I think that's so. And to do that, I want to start by just talking about publishers and what publishers look for when they get ready to put something out to the public. What publishers want is some amount of assurance that the stuff they're putting out is not going to be copied more than a certain amount. They have to have some guarantee that they have some control over the number of copies made or other uses made of their copyrighted works. And the conventional wisdom is that what publishers do is rely on copyright law as the means of control. That's the focus, that's the be-all and end-all. It's copyright law that it guarantees them the right to control copying and so forth. And actually that's not totally accurate, and this is a thing that people often miss. The actual protection that publishers rely on consists of 4 things. Copyright law is just one of the 4 things, and I think of it as sort of making a big pie with 4 slices. Copyright law is one of those 4 slices, but another big slice of that protection pie is the practical limits of the state of the art on what you can copy. And I'll give you an example. If you think of something like the National Geographic magazine, National Geographic can be copied. People can copy that. But who would bother? If you put that on a photocopy machine, you get a gray piece of crappy paper, and it's not slick, and it's not colorful, and it's just not good. And as far as I'm concerned, the National Geographic could probably ignore copyright law, could do away with copyright law, and it really wouldn't affect their market for the sale of the magazines, because nobody's going to bother. If you try to make an accurate copy, a good copy enough that competes, you're going to spend more than the National Geographic spends, and it's just not going to be worthwhile. So a major form of protection for a lot of works is just the built-in limits on the state of the art for copying. Now, it varies, of course. Some things are easier to copy than others, and there's no doubt that software falls in a different category, which I'll get to in a minute, but certainly the state of the art is one of the ways people rely on for protection. A third way, if you count copyright law, law, and the state-of-the-art on copying a third way, and the third slice of the pie, are special technological restrictions on copying. This is the kind of thing where you buy some cable systems or satellite systems and the signal is scrambled, and then you have to buy the descrambling device. Well, the descrambling device is a technological, a special purpose protective scheme. You also saw that, or you still see it actually on computer software where people make copy protection schemes that mean it's difficult to make a copy of the software. The state-of-the-art permits completely perfect copies of software, but some people sell software with these little schemes that make that more difficult. So it's a special purpose kind of scheme. You even see sometimes CD-ROM people selling CD-ROMs to libraries in their own computer, and the computer comes without a floppy disk and without any way that you can make a copy. The state-of-the-art would permit it, but they've made a special sort of change to the PC so that you can't make copies, and that's a similar kind of thing. Now, so that's three means, and the fourth means by which people protect the works that they release to the public is contract law. In the old days of computer software, when people wrote software for mainframes, it was typically on a contract basis. It wasn't the mass market. You just reach an agreement with a buyer, and the agreement said, we'll write the software for you, and in return, you won't distribute it to anybody else. And whether it was copyrighted or not didn't matter much because you had a pretty good contract basis for that kind of protection. So the key point I want to make at this stage is simply that people rely, publishers, producers of copyrightable works, rely on all four things, and the mix of things varies depending on what it is that you're selling, but all four things are relevant and important, and together they make a pie of a certain size, and that size represents the overall amount of protection that a publisher needs to be assured of some return on the investment and to enable them to release the work to the public. Now, it's perfectly obvious to all concerned that with digital, the world of digital materials and digital publishing, it becomes much, much easier than in the world of print publishing to make copies. And those copies are typically perfect copies. You can copy Lotus 123 and the copy's just as good as the original. You can copy digital music and the copy's just as good as the original. And so much of our world is moving to a digital format that the amount of protection you get from the state of the art, that slice of the pie is rapidly diminishing. Now, what that means, and I think this is something people sometimes miss, is if that one slice of the pie is shrinking compared to the print world, and it most definitely is, if a publisher is going to keep that whole pie from collapsing and reducing the amount of protection they have, they've got to build back up those other slices. They've got to rely on something else besides the state of the art, which is a practical limit on print materials, not much of a limit on digital materials. So they're going to be looking to the other three forms of protection in order to ensure that they have the same overall level of protection that they're used to having. They will, in the first place, they're going to try to beef up the Copyright Act by making the statutory provisions stronger, make that a bigger slice than it was. They will also turn to special technical provisions, and you will see that already in terms of encryption. People are talking about selling encrypted materials so that they can control reproduction and so forth. And they will turn to more contract limits. The push for statutory changes to beef up the Copyright Act is already underway. You may be familiar with the NII, I can't remember the title, the NII working group or whatever it is, that's addressing issues under the Commerce Department formed this group to address issues involving the national information infrastructure. There's a subgroup working on copyright and intellectual property rights. They have already proposed in a draft form some enhanced statutory provisions which are directly responsive to publishers' desire to have these greater protections through copyright law. I think that's proving controversial. And my expectation about those statutory provisions is so much of congressional activity these days involves competing interest groups. There are going to be interest groups fighting this out. The result is likely to be a compromise that will give publishers some of what they want by way of enhanced copyright protection, but not all of what they want. And so they'll not be able to fill up that pie with enhanced statutory protection. That means they're going to turn to the other two things, the special technical restrictions and to contract restrictions. Now, I don't propose to address the technical restrictions today. I think that's going to be important, but that's not the focus of my talk. I propose to talk about the contract restrictions, the desire to control reproduction and use through contracts with individual users. Contracts are going to be important for several reasons. One is, as I've just said, greater pressure to fill up that pie with something. But there's another thing that people don't realize about contracts. Contracting in an online world can be a lot cheaper. Worldwide cheap communications means that the cost of reaching people and transacting with people over issues such as copyright is lower than it used to be. So what we experience on the net is a great drop, actually, in transactions costs for forming contracts. That by itself would push people to make more contracts, because if you lower the price of doing something, people are going to do more of it. If you lower the price of contracting, people are going to do more contracting. And also a second thing, the net now permits something that's very difficult to do in print, and that is to monitor and price on a per-use basis, on a very fine-grained basis. Today, if someone sells a book, they don't charge you for every page you read. And people just think that's the height of folly. Oh, how stupid, how charge per page, that's ridiculous. They tend to carry that over to the digital world and say, it would be outrageous to charge per screen that I read or per word that I look at or transmit to my computer, assuming that it's somehow inherently true that no one should price on a per page or per use basis. The only reason it's not done with books is it's not practical to do it with books. There's no way to monitor and to station someone in your home to see how many times you read a copy of a book you've just bought. It's not practical. However, it is practical with digital technology and computers. So when you access something over the internet, it is perfectly practical to log every access, to log every screen, to make a record of it, and computers can do the accounting. Right? They can not only track it, they can do the accounting, they can compute a bill. And that also means pressure to sort of do fine-grained monitoring and pricing, again, based on contract. We're going to make an agreement with you. If you want to access our site, you can. We're going to charge you in the following way per access and so forth. So I think we'll expect to see that. Plus, not only is it not inherently true that you shouldn't price that way, the reason people want to price that way is you can make more money. If you think about books, suppose someone sells a book for $25. There's always some people who are going to get a lot more out of that book than others. They're going to read it more often, they're going to turn to it more often, they're going to enjoy it more. They would be willing to pay $30 or $40 or $50, but they don't have to, because books, it's not practical to do anything but charge a single price. Right? What publishers would love to do is price according to the amount of use. If this book is worth $50 to you, we'd like to charge it $50 to you. And if it's worth $35 to you, we'd like to charge $35 to you, because they can capture the value that everyone feels for that book. You can make a whole lot more money. You can do that electronically, and that's why they'll want to do that electronically, because it enables them to charge depending on the value consumers put on their work, and enables the companies, the producers, to make more money. Okay, so what we've got is pressure for publishers to turn to contracts. Pressures because the state of the art is not going to help them out, because they're not going to get everything they want to out of the legislative process, and because contracting is cheaper over the network, and because they can charge on a per-use basis. All of these things suggest a great deal more turning to contracts as the basis for payment and reimbursement for digital materials. Okay, now the problem with that is that is going to collide with users' expectations and desires. And users, by and large, feel that in this new age, if you can copy, well then, by God, you ought to be able to copy. If I can make a copy, the law should allow me to make a copy. And there's this tremendous expectation by users that the change should be toward greater freedom to copy, fewer restrictions on what they're doing. And that's going to run head-on into the publisher's desire to exercise more control, more per-unit pricing on the basis of contracts. And what that's going to lead to, I think, is a focus on the preemption doctrine of contract law, of copyright law, and in particular, arguments over whether or not copyright law should preempt certain contractual restrictions on the use of digital materials. Now, I'll tell you just briefly a little bit about preemption doctrine, and then go on to say a little bit more about why that's going to be the battleground, I think, of the next decade. Preemption in the Copyright Act is controlled under Section 301, which is just a provision of the Act. And what it says is, if a state law attempts to protect a work that is the kind of work copyright protects, part of the subject matter of the copyright laws, and if the state law attempts to grant rights in that work that are equivalent to the kind of rights that the Copyright Act provides, then the state law is preempted and the Copyright Act controls under the Supremacy Clause of the Constitution. Now, the problem with this doctrine is not in the concept, but in the implementation. It's very fuzzy, it's a very murky doctrine. Congress set out to make a clear dividing line and resulted in making a very blurry dividing line between state and federal protection. And all kinds of state laws have been subject to the preemptive thrust of Section 301, among them state trade secret law, state unfair competition law, state invasion of privacy law, the right of publicity. All of these have been preempted in certain cases by the Copyright Act, and in particular, of course, contract law, which is a body of state law, subject to preemption like any other body of law. Now, the basic idea of contracts is that with regard to copyrighted materials, contracts are a good thing. I mean, the idea is if you write something, probably, create something, software, book, novel, painting, whatever, generally speaking, the way you make money is you contract with a publisher or a distributor or somebody else for them to sell it on your behalf in exchange for royalties. And this is the fundamental way copyright earns money for authors. So I think there's not going to be a problem with simple transfers of copyright in exchange for an agreement to be paid royalties. That's not going to be a problem. The problems are going to come up with other sort of cases that aren't that straightforward kind of case. And I want to give you an example of two kinds of cases in which this sort of problem has come up. You're a lot quieter than my classes are, thank you. I don't risk taking a drink of water in class because they'd all leave. Just to give you two cases illustrative of the problems. One is the Warner Brothers case involving blind bidding, and one is the Vault versus Quaid case. And the blind bidding thing is a movie industry practice. What happens is movie distributors go to theater owners and they negotiate over what movies the theater owners are going to show. And the distributors say, you've got to agree to certain minimum royalty payments, certain guaranteed reimbursements to us, or we're not going to let you have the movie. That's fine. But the trick is, what they say is, you got to agree to all this stuff before you see the movie. We're not going to let you see the movie. You're just going to agree to give us a certain amount of money and hope you make it back. You can hope it's a good movie. You won't know. And theater owners just were freaked out by this practice. And many of them in many states went to the legislature and said, you got to stop this. They're forcing us to take these movies sight unseen. We don't want to do that. Pass a statute that prevents blind bidding. All right? And many state legislatures did that. They enacted statutes just like this. Whereupon the movie distributors took them to court, arguing that these restrictions on their right to distribute copyrightable materials impermissibly interfered with their copyright rights and should be preempted by the Copyright Act. We have the right under the Act to distribute in whatever terms we want to. You're restricting us under state law. We want that state law preempted. By and large, those lawsuits have failed. For the most part, courts have said, no, this isn't preempted. It's a state law and it's okay, and there's a lot of reasoning going on, but the basic answer is not preempted. To contrast that, let me give you the Vault versus Quaid cases, which is a case involving computer software. I talked earlier about technical means of protecting software. Copy protection schemes are one way of doing that. The Vault company made a copy protection scheme which it sold to software distributors, whereby software distributors could sell their software in a form that was difficult or impossible to copy. Vault wanted to put on the software a little notice that says, no one can reverse engineer our software, no one can figure this out, you agree not to reverse engineer, you won't do this, so as to protect their scheme of copy protection. All right. The Louisiana legislature, I don't know why it arose in Louisiana, someone may know that, but the Louisiana legislature passed a statute saying that kind of contract stuck on the front of a software box is legal and enforceable. It's called a shrink wrap agreement. The idea is that the software is sold with a heat shrink plastic wrap, and the notice on it says, if you read you read these terms, if you rip open the package, you've agreed to them. And the terms say, don't reverse engineer this, don't analyze it, don't figure it out. You open the package, you've agreed to it. In Louisiana, the legislature said that kind of contract is legal. It may look like a contract of adhesion or not, or whatever. We're declaring it's legal and enforceable. All right. Vault sold its copy protection scheme. Somebody got some of the software and promptly reverse engineered it, made copies, did everything they could, figured out the scheme, and then sold an undoing scheme that allowed people to copy protected software. Okay. Vault sued them and said, look, we had a contract. Look on the box. It says you can't reverse engineer it. Here's our Louisiana statute. It says it's valid. Breach of contract, copyright infringement, whatever. That went to court, and the competing company argued the statute in Louisiana should be preempted by the Copyright Act, because the Copyright Act authorizes a certain amount of copying of software. This statute says you can't do that under these circumstances. The statute should be preempted. The result? It was preempted. The court said, yeah, this kind of state-authorized contract, and it's contract law, is preempted by the Copyright Act, Section 301. Now, I don't propose to resolve like which of these is right or wrong, merely to show you that the preemption doctrine is not well settled, is not fleshed out, and it can arise in the context of contracts that purport to limit the use of copying of software. And in addition to Section 301, making the picture a little more complicated, a little more murky, there is a notion of sort of generalized constitutional preemption, where even if the terms of Section 301 are not met, some courts have said on general principles of federalism, supremacy of federal law, there are times when copyright policy simply overrides state law, apart from Section 301. And I don't, again, propose to analyze that, but simply to say, you got this big bunch of murky doctrine. You got this big preemption doctrine that's looming out there, and it doesn't have very well-defined boundaries, and some of it's based on a statutory provision that itself is unclear. Some of it's based on general constitutional provisions, which are totally unclear as far as I can see. Okay, so that's the picture. So you think, okay, so the doctrine's murky, so what? Lots of doctrines are murky, lots of doctrines are a problem. Well, there's another big problem that comes from our changing perception of what the purpose of copyright, the copyright statute is. Over the last 200 years, to say I'm doing a lot of copyright history research these days, over the last 200 years, the way we look at copyright has changed in a kind of fundamental sense, and it's going to cause part of the problems that I'm talking about. I hate to say the original view of the founder, but I guess I did be an originalist on this, but the founders, no question about it, the founders' view of copyright was that it was a property right. Right? 18th century was full of notions that property right is the way you do everything that results in people being able to transact business and freedom from the government and so blah, 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 blah. Copyright was seen as a property right. You got it, you can make whatever deals you want to. You can sell it, you can keep it, you can license it for a short term, for a long term, you can license A, you can not license B. It's your property. You can do with it whatever you want to do. And that was the sort of property rights view. Now, what that leads to is the sense that the interests of producers and consumers of copyrighted material are then balanced on an individual basis. You sell your copyrighted work to A on some terms, that's the balance of interest that you achieve, the two of you. If you want to sell it to B on different terms, you've achieved a different balance of interest. But the whole idea of the competing interests of producers and consumers was, with a property rights approach, they are balanced on an individual basis, transaction by transaction. Right? Now that's the old view. Over the years, over 2 centuries, that view has shifted. People tend today to view the Copyright Act not so much as the creation of property rights that you can do with what you want to, but as a kind of liability statute that spells out in great detail all the things you can and cannot do with copyrighted works, both for the owner and for the user. Owners can do A, B, C, D, E. Users can do D, E, F, G, H, and it's all spelled out in great detail. And that's a different view, because what that means is the interests of producers and consumers are not balanced on an individual transaction by transaction basis, but they are balanced by Congress for all transactions in very large categories. There is constant reference in the literature today, something you did not see 100 or so years ago, constant reference to Congress having drawn a balance, Congress having defined a balance, Congress having balanced the interest. And it's the view that Congress spells out the terms of all the bargains over copyright by defining with great specificity what you can and what you cannot do with copyrightable works. Now, if you take that view, which tends to be the contemporary view, it is clearly the view of copyright users, like librarians and educators, who are the main organized interest groups on behalf of users. That is clearly their view of what the Copyright Act is all about. You can see where the problem comes. If Congress has balanced the interests and said what users and producers can do vis-a-vis each other, you can't alter that by a contract, because that would impermissibly interfere with the congressional balance of interest. You'd be distorting what Congress intended to achieve. Consequently, it's going to give rise to all kinds of arguments when people make a contract and say, do you agree that you won't make a use of this work that would otherwise be a fair use? 100 years ago, we would have upheld such a contract. As long as it's voluntary, we would have upheld it. Today, those kind of contracts are likely to be challenged as affecting Congress's balance of interest in the fair use area. So now, as far as I'm concerned, both views of the Copyright Act as a property creating statute or as a liability defining statute make some sense. And there's some warrant for interpreting, finding both things in the Act. Certainly the Act does create a kind of property right. Certainly it does specify certain things you can and can't do. And there's good ground for either argument. But my point is that the contemporary view that Congress is balancing interest is running us into a major conflict in the cyberspace community. And just to summarize that, producers are going to have to turn to contract to fill up that pie of protection because they're not going to get it from the state of the art. They're going to want to turn to contract because contracting will be cheaper tomorrow than it is today over the network. They will want to turn to contract because they can do per use, per view pricing, which makes them more money. That's a force coming in this direction. And you look at users coming in this direction saying, this new technology means we should have fewer restrictions, not more, coupled with the view that the Copyright Act really defines the rights and duties and is a congressional balancing that can't be undone. And the battleground is the area of preemption. And I wish I could tell you exactly how I thought it was going to come out. I don't know exactly. I suspect that Congress will end up modifying the preemption provision in the Copyright Act in the next few years, probably creating a series of compulsory licenses. But in the meantime, it's going to be a terrific war in the cyberspace community because of these two opposing forces that are coming more and more head to head. So that's what I want to tell you about today. Thanks. Yeah. Oh, it's in the 80s. Dan, you know that? It's fairly recent. Late 80s, mid 80s. Yeah. Sure. Yeah. And 100 years ago, it's just like the Copyright Act provides that the owner has the exclusive right to do something, and yet people sell that right all the time. All right? It could provide for the right to archiving, a right that you could sell, right, by contract. But that's the default case. That's what I mean. The view is, oh, no, Congress has drawn the balance. You can't undo that balance. That's precisely the problem. Mm-hmm.
If you watch your software, in a specific example, like those 1, 2, 3, and you used the original, you could not take it back.
Yeah.
They had a copy protected.
Yeah.
Until the folks that were, their copy PC boards.
Right.
Still that. And,
Right. Yeah.
And you trash that, you're out $400 or $500.
Yeah.
Yeah.
Well, I tell you, sure. Yeah, but the market would have corrected that, just as the market did away with copy protection for business software because nobody wanted to put up with it. Yeah, but I think that section allows you to archive. There's a section in the Copyright Act that says you are allowed to make a copy of a program if you have to do that in order to run it. Well, talk about a superfluous provision, because what that supposes is that in the absence of that statute, people like WordPerfect would come around and say, oh, I know you bought our software, but you can't run it. You know, they wouldn't do that. They wouldn't do that. So it's a superfluous provision that ran us into trouble in the Vault versus Quay case. That's my view. You know. Yeah. 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 Okay. Wow. Okay.
The reason that's interesting is that when the balance is being struck by Congress, and things are being done in the courts, assume this common law model of contract in the United States and in foreign common law countries. As someone said earlier, when we come to the internet as an international system, there are other models of contract out there, like the civil law, Louisiana idea of contract, that will start to run up against them as we become involved in international
Yeah, that's a good point. Yeah. Yeah.
The schemes of compulsory licensure have always kind of been on the outer edge, arguably, of what the copyright clause of the Constitution permits Congress to do. It's something other than the property right that one might argue the copyright clause contemplates. Are the kinds of schemes we can predict to come up going to further stretch the constitutional concept of copyright where they might be challengeable?
No, I don't think so. I think that view, the founder's view of property rights and all that stuff is just so gone by the board today that almost anything goes, I think, for Congress. And so I think challenges like that will probably prove unsuccessful. In the same way that people argued at one time the Constitution says writings, Congress may protect the writings of authors, and then people have argued, well, is an ashtray a writing? You know, because you can protect an ashtray as a work of sculpture, it's been done, you know, and that just, people just go, yeah, we don't want to hear it. And so I don't think that's going to happen. Yeah.
If my understanding is correct, at one time, possibly not presently, you had both the registration copyright law to protect the work as well as the common law copyright law.
Yeah, there's...
Recent changes have, this is a question, I guess, as we haven't phrased it. Do the recent changes cause you to lose your common law rights if you're not registered within 30 days of the publishing?
No, the change is that there's almost nothing left of common law copyright. When the federal statutory copyright kicks in whenever you fix something in a tangible medium. So if you're writing notes, if you're doing a draft of your novel, it's being copyrighted as you write it. Yeah, you don't need that notice anymore. And so the only thing that's left of common law copyright is for works that are unfixed, which is to say ad-libbed speeches or ad-lib dance routines that are not recorded anywhere. But anything recorded, and that could be on a magnetic disc, could be you speaking to a tape recorder, anything that's recorded is federal copyright protection. So there's very little left of state common law copyright. No, there's no requirement that you register to put the symbol on. There's no requirement you put the symbol on anymore, but you can. Yeah, but you can. You don't have to register. The only thing you have to register for is to file suit. Well, you get some advantage. I forget that you get some advantages if you are registered, but basically we have pretty much done away with these so-called formalities, any steps you have to take. They're really, it's good if you have a commercial work. It's good to register it. There's some advantages, but it's not essential. Yeah.
Wondering how copyright or the ancient doctrine work in this situation. I think there's been some use of it, I'm sure, where some user on the internet takes someone else's copyrighted work, sort of out of economic, and puts it on the internet so they can be called up and
Yeah.
reproduced by whoever else is logging in and get place.
Well, my view is I tend to view copyright sort of as basis of its underlying principles, and I would have no trouble in finding a provision in the statute that says that's unlawful. That's the equivalent of a public distribution or a public display or something. In point of fact, it's a little bit unclear as to exactly what it is, and the recent working group on the National Information Infrastructure Intellectual Property Laws has proposed that we add a provision in the Act that says transmitting a work over the net is an infringement of the owner's, or the owner has the right to do any transmitting of the work. Okay, and so it would make it even plainer than it is that that's an infringement. That would be publicly transmitting the work or making it available for transmitting would be an infringement. I think it would be anyway, but the proposals are to clarify that. But that's controversial because a lot of people feel like I'm not making copies, I'm putting it on the computer, other people want to read it. It's just the same as if I had a book in a library and people came in to read it. So why should it be an infringement? So it's controversial and it may or may not be enacted, but the proposal is to define that as an infringement. Yeah. You mean works that are put into things like Dow Jones and they pay? They have licensing agreements with the owners. Yeah.
There used to be a lot of argument about whether you, as a consumer, bought a product or only bought a license.
Yeah.
Is that still debated, and where is that debate?
I don't know if it's software. There's something called the first sale doctrine in copyright law. If you sell somebody a copy, a book, they can, other than publicly reproducing it or performing it or distributing it, they can do what they want to with that particular copy. They can sell it, give it away, lend it, so on. That's only if you actually sell the copy. If you just license someone the use of the copy, they can't do whatever they want to because it's only by agreement that they have the right to do anything. So what software producers say is, we're not selling you the software. There's no first sale doctrine here. We're not selling it. We're just licensing it. I don't actually know if that's been squarely challenged. Has that been that? I don't know if that's ever been squarely challenged in a litigation context, whether that really is a license or is a sale by some other name. And I don't know. I'm not sure.
When you buy the discs, you're allowed to actually sell that disc.
That's right. Well, because the statute talks about rightful owners of copies and other things, but I think the software producers would still like to say you don't own it. You're not the purchaser. You're just the licensee. But I don't think they've ever tried to really pursue that vigorously in any kind of sensible, any kind of meaningful way. Yeah, I don't. Yeah, okay.
And I can see where that was effective, 15 years ago, where the only people using computers were specialists and such. But nowadays, everyone has one. And I go up to Walmart, and I got a little that receipt says I have bought it, I'm not renting it.
What does it say on the box? And we're weird. Sure. And I think if one were to look for it, I think one could find examples of where public perception differed sharply enough from what the law provides, the law eventually bends to accommodate. And probably the best case of that is in home copying of tapes and music. For years, some people argued that it was a fair use to make copies of music, tapes at home, borrow your friend's album, make a tape of it. I never thought it was. I always thought it was infringement. And when my family bought a tape deck some years ago, I insisted that we buy a tape deck that had only one deck. I said, the only reason you buy two decks is to make copies of copies of music. We're not going to do that in my house. And then, but everybody thought that was okay. And in 1992, they finally amended the statute and said, it is okay. So we bought a deck with, two decks. We did. That's true. Yeah. Yeah. I'm sorry, there's no recognized signature? Yeah. I think it'll affect, high-priced transactions for sure. I guess I'll say two things. First of all, the idea that things have to be signed and stuff, most contracts don't have to be. I mean, if you can just show, if a printed email signature that could be forged, if you can show wasn't forged and was actually the person's signature, was actually their email message, it's good. You can make a contract. So the one thing is some contracts are valid anyway. The other thing is I think the technology is evolving and we will get that stuff. The people are working like crazy on doing commerce over the net and secure transactions and authenticated transactions. And there are technologies, they're just not conveniently incorporated into popular software. But there are technologies, public key, private key encryption, and to identify yourself as the author of something. And I think we will turn to those, and I think that problem will sort of be solved, and probably before very long. Yeah. Hmm? New legislation? Oh, mandated encryption. If you ask me, do I see a need for it, the answer is no, I don't. If you ask me, do I think we might get it, I think we get a lot of things we don't need, so yeah, we might. But yeah, I think that's a classic problem that the market could solve. I mean, if you're a seller and you want to know the buyer's the buyer wants to know you're the seller, you both want to know you're going to deliver on the goods, and it may be that these techniques just have to evolve to allow people to transact business, and if that's so, they will evolve. Yeah.
What do you feel of the effectiveness of the current criminal liability that's been added to the copyright statute under Bush?
Yeah, I tell you the truth, I haven't really looked into it to know or to think much about it. I know it doesn't apply if you post software on your bulletin board system for free distribution. There's a recent case, the Lamakia case, where a guy ran a bulletin board and he encouraged people, give me Lotus 123, give me WordPerfect, and I'll make it available for everybody. Right? And they prosecuted him, no, actually for wire fraud, because he wasn't charging, so he didn't fall within the criminal provisions of the Copyright Act. They charged him for wire fraud, and the elements were not satisfied, and it was an unsuccessful prosecution. But I think that, so I'm really not very familiar with the criminal provision of the Copyright Act, so I could be wrong, but I believe it by definition requires that you're doing it for commercial purposes.
Is that Massachusetts case?
The Machia.
Does Massachusetts have a specific statute?
Many states do, but I think this is a federal prosecution in the wire. Yeah. Yeah.
The question is, some states have a value of the goods provision.
Yeah, but yeah.
I'm saying that maybe prosecutable or other states.
Possibly. And he could have been sued, and may still be sued civilly by the software companies. Clearly, it's violated the Copyright Act on a civil basis. I think the question was whether it was a criminal violation. Yeah. In his case, that question didn't arise because he was doing it on purpose, but it does arise in suits like the current suit against Prodigy for the defamatory message posted on Prodigy, and there's a lawsuit now against Prodigy, not the person who wrote the message. The person who wrote the message, incidentally, isn't identified because he used a fake name and ID. But the suit's against Prodigy, and that's the kind of question you're talking about, which did not come up in the Lamakia case because he was the CISO. Yeah. Okay, sure. Yeah.
Providers claiming that people posting to bulletin boards have posted
Copyrighted materials.
And the like. But it's got to be going against the post that they were going against the system of administration. And I read a paper from the BFF on this issue.
Mm-hmm.
Rather than to try to sue the Oriental Commission out of existence instead of not their side of the story.
Mm-hmm. Well, the system administrator's position in all the big services is we'll accept liability for wrongful messages, copyright infringing, trade secret, divulging, defamatory. We'll accept liability once we know and have had an opportunity to do something about it, but not before that. And they've drafted a lengthy position paper with this copyright group arguing for that kind of provision in the Copyright Act and other provisions as well. It's a perfectly sensible argument, and they may get that, but it's uncertain at the present time. Not to operate it when you're drunk? Is that? Okay. Okay. Of course, it begs the question, of course, of what is negligence? Must you screen every message if you're able to? And a Prodigy, CompuServe, they get 50,000 messages a day. You could argue that.
Thank you.
Yeah, sure thing.
And also thanks to Trotter for not taking too much offense at the unintentional slight. But again, thank you for Trotter. Actually, the 2 points that were just raised actually dovetail quite nicely with our next presentation. The one note on the Church of Scientology issue. Unfortunately, Shari Steele is not here from EFF today because of the snow, and she would have had quite a bit to say about that. For position papers on that, you can look at our website and see some of the most recent information that EFF has put out. It is a rather interesting situation, but as to the whole notion of sysop liability, this is actually, I mean, I don't think I could have asked for a more perfect lead-in for our next speaker. An interesting story how our next speaker is with us today. This is a perfect example, again, of what I would call a community existing. The LTA, the Law and Technology Association, posted information about the symposium about 2 months ago on the internet, on the World Wide Web. And we had not gotten to the point where we were ready to mount a concentrated effort at publicizing the event. We were still getting all the speakers together, we were still figuring out exactly what the schedule was going to be, and we didn't really want to make a big splash yet. We simply wanted to put the information out there so if anybody happened by, they might see it. Well, somebody did. We still don't know who, but someone saw it, copied it into a small announcement announcing our conference, and then circulated it by email. And I've seen to date 6 different versions of that particular announcement that had nothing, that didn't come from us, which was great. I mean, as far as we're concerned, again, the more publicity, the better. Our next speaker, Peter, happened to receive one of those announcements and then contacted me and asked if participation was still being sought and whether or not he could be a speaker in this symposium. I was more than happy to include him. He is a very welcome addition to our program. He is not included in the brochure because the brochure went out before we had actually secured the details with Peter. Peter is the Executive Director and General Counsel for the National Public Telecomputing Network. And the NPTN, you have extensive materials in the registration packet. What they do, the best analogy I've heard and they mention is that they are kind of the NPR or the public broadcasting of cyberspace. And I think that's probably an appropriate analogy, and I think I'll let him expand on that in a minute. Peter generally provides advice regarding computer-mediated communications law and policy and communications development on the information infrastructure. He is also involved with an industry coalition, the Online Services Working Group, which is trying to maintain the internet as a self-regulated industry, if I can call it an industry. Given some of the focus today, again, there's an obvious tension there. There are some that would rather there be increased government control, and those who maintain quite hard to the notion that the internet should stay decentralized, as Professor Burk mentioned earlier. So I please would welcome Peter Harder to discuss the issue of acceptable use policies.
Morning. It's a pleasure to be here. The reason why I first emailed the folks here at LTA was that in their announcement I saw that the Central Virginia Freenet was a primary sponsor of this event, and hence piqued my interest since the Central Virginia Freenet is an affiliate of MPTN, and I thought it would be a nice coincidence if in my travels I could get out and see some people on the front lines and meet them face to face. People I often talk to for quite a bit by email or by telephone or fax, but never get to see them face to face. And with the rate of our network's growth, it's increasingly difficult for MPTN's small staff to ever meet people face to face. That might change in May. We're having a international annual meeting in Tempe, Arizona at our affiliate down there, May 17th to the 21st, which is open to the public, and should anyone be interested in attending, if you permit me to do a plug here, you can ask me questions afterwards about how to get more information about that event. But again, it's nice to be here. I'll be going out to dinner and talking later with people from the Central Virginia Freenet, and then spending the week here in DC on business, somewhat related to what we talked about today, these issues. But MPTN is based in Cleveland, Ohio, and the founder of the first Freenet back in 1984, my boss, the president of MPTN, Thomas Grundner, when he was in the faculty at Case Western Reserve University in Cleveland, he got curious about BBSs and went down to a computer store in the early 80s and bought an Apple and just started reading the manual from front to back. And that's probably the first and last manual this man's ever read. When I came on board at MPTN back in August, I happened to come from a Windows DOS environment, and the majority of people at MPTN are Mac heads, so I was immediately converted, so now I'm a switch keyboarder, I guess. And I've yet to read a manual. It's just, there's no time to read manuals. But at the time, back in, I guess, 82, Tom was curious and read the manual, learned what made that computer tick, and created a BBS called St. Silicon's Hospital Information Dispensary. He was adjunct to the medical faculty at Case Western Reserve University Hospitals and was in charge of communicating information to the medical students on behalf of the medical faculty there. And so when students were at home or worked late at night on their house schedule, not using computers at that time. I didn't start using email till '86, so that was before I was online. But St. Silicon's Information Dispensary evolved into the Cleveland Freenet, which was at the time different than what a BBS was, in the sense it was a multi-user computer connected to the internet. At the time, a BBS was, the BBS paradigm, which is continually changing, was at one end of the spectrum, and commercial online services like CompuServe were at the other end, and Freenets were in the middle. But now, because BBS is getting to be multi-user connected internet systems, and Freenet online services are having internet connections and gateways and backdoors and interfaces and whatever else they call it these days. It's all blurring up. So the continuum is changing. But the Cleveland Freenet, founded in 1986, arriving from Ohio, so thanks for coming. It's good to have some people from Ohio here, because I think Ohio, when I first flew out to Ohio for my interview back in June, I was reading the AAA guide and talked about how Mr. Cleveland was the missionary who founded the city on Lake Erie and during the 70s because of the pollution. It became known as a mistake on the lake. And this cleaned up since then. And the industrial age started there, hence the pollution, but with CompuServe being in Ohio, with OCLC being in Ohio, with MPTN in Ohio, my boss Tom Grundle likes to think that the information age started in Ohio. But that's just for background, not for claiming any right. Because we're an international company despite our name. We have 46 systems located in 4 countries online, US, Canada, the Philippines. Actually, it's more than 4 countries. US, Canada, Germany, Sweden, Finland, Ireland, and the Philippines. Nothing in Manhattan, go figure. But we also have approximately 120 systems in various stages of organization in 10 countries and counting. But anyway, that's the background of the company, where I'm from, and why I'm here today, and why I like being here today. But to get to the issue of acceptable use policies, acceptable use policies is the general umbrella term, generic term for the governing rules between the sysop of a system, be it a BBS, a commercial online service, or a Freenet, and its users. AUP can be just a one sentence, please use the system according to common sense, or it can be a very long and detailed document with subparts and subagreements dealing with copyright, privacy, and decency issues. The Freenets in our network all have very different AUPs because MPTN has decidedly not imposed a uniform AUP on its systems because we found it more instructive in our family of systems for people to come up with their own standards through their governing boards at the local level. Ours is a highly decentralized network, and people come up with very creative solutions. piece of email, he included his email address in the article, and I got an automatic response saying, I'm getting too much email. Maybe when he wades through all the email he has, I guess in response to that article, I'll see what his responses to my questions were. But initially, when Rick wanted me in the hallway this morning to speak impromptu this morning, I thought, well, I could talk about use policy as a hot topic. And then the comment by Rick about Cantor and Siegel, and they're posting a message to thousands of listservs. That act brought in so much criticism because it not only went against common sense, but also just violated people's formal, informal, typical use policies. Even though there is no uniform one, there are general common themes in most any AUP, and that's why it caused such an uproar. And if Cantor and Siegel take the point of view that